Welcome to Digital June, the second session. We had a very fantastic previous session where we had the opening keynote conversation and keynote panel, which basically set the stage for this conference and talk about different opportunities and talk about different areas where issues are there. So now from this session onward, now we are going much deeper into the discussion. So the first thing is, okay, now we know about digital economy in India. We know about the growth factors in India. We want to be part of that growth story. So our next session, this session is really very interesting session. It's about entering digital India. And I will introduce the panel. Before I go to introduction of the panel, I would like to thank our supporting partners. There are several prestigious organizations have supported this conference, including Center for Digital Future, CUTS International, FICCI, IAMAI, IFA, IVCA, NASCOM, Thai Silicon Valley, US-India Business Council, Wilson Center. Also, we are very fortunate to have Brand Capital International as a media partner for this event. Now you can learn about them, all these partners, by going into the lobby and click on their logo to get to their kiosk. The panel that is coming up is Entering the Digital Economy in India. Nishith Joshipura, who is the leader of private equity and M&A practice at Nishith Desai Associates, is the session chair. And we are very fortunate to have Eric Winston, who is Executive Vice President and General Counsel at Mphasis. Harshita Srivastav, who is the leader of venture capital investment and startup practice at Nishith Desai Associates. Naval Taraporwala, who is President and Board of Director of Brand Capital International, which is the strategic investment group of the Times Group, which also has many leading publications, including Times of India and Economic Times and many other. And we have Ratnadeep Roy Chaudhary. He is the leader of private equity and M&A practice from Nishith Desai Associates. Just quickly, as a background, the views that are presented by speakers at this conference are the views of their own, their personal views. They are not necessarily of the organization for which they work. So without further ado, welcome again to Digital June, and I hand over to Nishal to take it forward.
Thanks, Mir, for the intro, and welcome to all the participants joining this session. In today's session, we are going to cover some of the interesting structures for foreign investors who are looking at investing in India and for Indian companies who are aspiring to go global. As we all know, the digital economy got a shot in the arm during the pandemic. Some of the biggest domestic and foreign investors pumped in huge amounts of money in digital infrastructure, ranging from cloud services to electronic manufacturing to communication network to data centers. Mass digitization has now become a reality not across the sectors but across the world. Some of the sectors within the digital economy that we saw, the valuations of which hit the roof, were EdTech, FinTech, AR/VR, and some of the other interesting sectors like health insurance also became quite interesting in terms of valuations. So with this background in mind, let me start the panel discussions with my first question to Harshita. So Harshita, would you talk about the interesting structures that foreign investors can use for investing in India?
Sure. Thank you, Nishchal, and warm welcome to all the participants for this discussion today. So I think in line with the with the topic of this panel, which is basically digital economy and entering digital economy in India, and how does it look like from a more structure perspective, or the when an offshore investor is looking at India from a from an entering or from a investment jurisdiction. So clearly, valuation and ease of exit become some of the most important considerations that are kept in mind when an investor from abroad or an offshore investor is evaluating an investment opportunity into India. The primary structures that we have seen, which is being used to invest in India, the first one being either investing directly into an Indian company from an outside vehicle, which is usually a outside India jurisdiction, which is usually a tax favorable jurisdiction like Mauritius, Singapore, Netherlands, etc. Two, whether it could be an investment in another, probably if I talk into the more US India concept, taking a cue from the previous session that we had in this series. So investing into a US company, which in turn uses an intermediary jurisdiction, say Mauritius, and in turn invests in an Indian company. The third being investment in an overseas company which has a subsidiary into India, and that's a lot of commonly resorted method of investment into India. And the fourth being direct investment into an Indian entity. Now, in terms of implementing these structures and more from a regulatory standpoint in India, any foreign investment into India can be broadly made under the under either of the three regimes, being FDI, which is the foreign direct investment. So setting up India operations or investing in India by non-residents essentially requires conformity with India's foreign exchange regulations, and specifically the regulations governing governing FDI, which is foreign direct investment. FDI limits with respect to shareholding of non-residents in an Indian company are divided under the regulations into prohibited, permitted sectors, and then there are restrictions in terms of choice of instruments that can be picked up under the root. And maybe when we go further into the session, we delve more into what the FDI policy or the regulatory regime around FDI looks like. The second popular route is the FVCI route, which is basically for investments made by SEBI-registered foreign venture capital funds. Now, in addition to investments coming into India through the FDI route, we have foreign investors who are registered with SEBI as a foreign venture capital investor and who are allowed to invest in Indian companies. Now, FVCIs are allowed to invest in in core investment companies in the infrastructure sector, asset finance companies, infrastructure finance companies. And there are certain special benefits accorded to an FVCI when they're looking to invest into India. For example, there's no pricing restriction as applicable to an FDI investor. There are no lock-in restrictions in certain scenarios where the company is looking to go public and similar. So certain key benefits which get attached to you if you're looking to invest as a SEBI-registered FVCI investor into India. The third is the foreign portfolio investor regime, which is basically for investments made by registered foreign portfolio investors. So separate and varying degree of regulations have been prescribed to govern the foreign portfolio investment regimes. SEBI and the RBI, under the extant Securities and Exchange Control laws, basically allow for portfolio investments in India by certain qualified foreign investors, again, without being subject to FDI restrictions at large. So these are the three broad regimes or the routes that we look at when we are looking at entry into India. Now, the other very important factor that is being considered is the choice of jurisdiction and the associated tax. So investments into India are often structured, and as I mentioned early on, through holding companies in various jurisdictions for a number of strategic and tax reasons. Now, for example, a US investor who's directly investing into India may face a lot of difficulties in claiming credit of Indian capital gains tax on securities against US taxes, and due to the conflict in source rules between US and India. And in such cases, and similar cases again, the risk of double taxation may really be avoided by investing through an intermediary holding company or an intermediary jurisdiction. Now, India has entered into multiple, double taxation avoidance agreements with different countries, and basis which basically a taxpayer may be taxed either under the domestic law provisions or the DTAA, whichever is more beneficial. Now, while choosing a jurisdiction, it is an intermediary jurisdiction or a holding jurisdiction, as you say, when entering into India, it becomes necessary to consider a range of factors, obviously, which may include a range from political and economic stability of the country, investment protection, corporate and legal system, availability of high quality, legal support, banking facilities, etc. Now, over the years, a majority or bulk of investments into India have, come from countries such as Mauritius, Singapore, Netherlands, which are obviously more developed and, have established financial centers that, that they have the ability and we have favorable tax treaties with those countries. So that becomes an important determining factor again in terms of which jurisdiction are you choosing to get into India. And I think lastly, from a more high-end tax perspective, important tax risks in terms of place of effective management, which is the POEM risk and anti-avoidance, need to be carefully considered and evaluated, while structuring and while looking at an acquisition or an investment opportunity into India. Over to you, Nishith.
Thanks, Harshita. So just to add to what Harshita said, I think one of the quantum shift that we have seen as far as structuring foreign investments in India is concerned is that earlier complex structures were something that were considered to be very glamorous and all the foreign investors were comfortable investing through complex structures. At that time, the regulators in India were also not very well coordinated. However, in the last few years, what we have seen is that more and more structures are getting simpler because the regulators have started talking to each other and they are keeping pace with the developments as fast as advisors keep. And which is why one of the big shift that we have seen in the structuring of foreign investments into India is structures are becoming simpler and simpler. So I think that's one big takeaway that we have seen in the last decade as far as structuring of foreign investments in India is concerned. So my next question is to Eric. And Eric, you are counsel of a large Indian listed company. It would be good if you can introduce your organization a bit and talk about what are the acquisition opportunities that you are witnessing, and at the same time, would you look at a typical
Nichelle. Happy to be here. I do wish, before I get started, it was different times for all of us and we could be together all in person for your digital June. However, we probably have this as our next best alternative, and I'm pleased to share the screen with you all if we can't be together on stage. And of course, before I start, also want to hope that everybody is and your families are staying safe and healthy and all doing well. I think, as you said, it's worth for me to provide some context on who Emphasis is and what we do, because this informs, in part, my point of view. We are an IT services company that leads with design and architecture to deliver next generation services that blend deep domain expertise with cutting edge technology. Our solutions are powered by tribes and squads, which are cross-functional teams that help to evolve our next generation offerings in areas such as cloud, AI, ML, and quantum computing, just to name a few. As you said, we're a publicly listed company in India and majority owned by Blackstone, with about 76% of our revenue coming from North America and 13% from the EU and the UK. We pride ourselves on innovative technology and services serving marquee customers across the globe, including the world's largest logistics provider, 6 of the top 10 global banks, 11 out of the top 15 mortgage lenders, 3 of the top global insurance companies. And if you add it all up, in the banking, financial services, and insurance sector, we serve 35 of the top 50 firms in the US. We have about 30,000 employees, and we have 16 represented in 16 countries by various entities around the globe. We are and have had tremendous success expanding in continental Europe and the UK for both new business and talent. And in fact, recently, Boris Johnson, UK's Prime Minister, announced that we've made some significant growth and investment in the UK. And so UK and EU are significant growth areas for us, both organically and inorganically. And before I get into some of the specific stuff on M&A, our mantra at Emphasis is customer first. And we take this seriously, and it's simply part of what is our DNA. And what we mean by that is that when we look to expand and grow, our domain expertise, our talent, IP, or by geography, it's always through the lens of the customer. We must be able to think through what serves the customer best in order to deliver solutions, services in digital and new gen areas that better, faster, and more efficiently serve the customer. And we do this through M&A activity, JVs, and other structures. Our ability to construct end-to-end digital transformation-led, complex, longer tenure deals is at an all-time high for us. And so that's in part accomplished through geo expansion, building out delivery centers in Mexico, Costa Rica, Taiwan, Estonia, to draw on different talent pools, to draw on diversity, as well as to provide our clients with a global opportunity to service them. And as I'm sure you can appreciate, when we're expanding, we do a buy versus build analysis. Because we construct our business so heavily reliant on new gen and digital services, we also work to fortify our partner strategies by through our channel partners such as Amazon Web Services, also known as AWS, Azure, Google Cloud Platform, and Snowflake, to name a few. At Emphasis, as I said, our acquisitions are very much client-led, and where we see the market and technology going, coupled with value, the right technology, and the right geography. Let me give a couple of quick examples of some recent acquisitions we've done. This past November, we acquired a company called Datalytics. Datalytics is a leading next-gen data engineering and consultancy company headquartered in London. They provide data engineering, data ops, and master data management solutions on Snowflake and Talent to clients globally. The previous year, we acquired a company called Stelligent in the US, which specializes in DevOps automation for customers on AWS. And recently, we announced a deal in the UK to set up a shared services platform in a joint venture vehicle to serve middle and back office functions while applying digital transformation using our unique front to back construct. I think it's worth spending some time talking about M&A process flow. And I think something that I've seen or we've seen is a change, I think, from pre-COVID-19 to a post-COVID-19 point of view, because there are some differences, and I think some of these may be here to stay. As we all know, pre-COVID, you could meet with targets in person to assess. We start our process by evaluating target management's COVID response and any structural changes that may have been made in the target's business post-COVID. Is whether we should contemplate a higher deferred component as compared to pre-COVID. We also do careful, detailed due diligence to include business continuity robustness. We look at sector concentration differently to assess exposure, both positive and negative. And from a pure legal point of view, we double click on reps and warranties and focus on force majeure clauses in commercial agreements in particular and in other agreements as well. We also move up and expand the scope of customer reference calls to prior to signing, and instead push them to example as from precondition to earlier in the process. Generally, at Emphasis, we work with cross-border, cross-functional teams of both internal and external resources. The business, finance, HR, CRO, legal, and corporate development all work closely with our auditors and our outside counsel. Because we are global, we can virtually work 24 hours a day, of course, no pun intended, to efficiently and thoroughly undertake early diligence that helps give our target confidence in deal certainty and assist us in making an earlier, more informed and cost-effective decision. I think my time is about up, and so I'll stop here. Thank you very much.
Thank you, Eric. That was quite detailed. Just like Eric gave us a perspective on Indian companies going global and what do they look at when they are acquiring targets abroad. We are going to get a different perspective from Neville, who is going to talk about the opposite, which is what do foreign companies look at when they are investing in India and what are the challenges faced by them. So Neville, you have worked with many US companies and you also assisted some of the foreign companies who are looking at investing in India. Could you share some of the challenges that you have faced while advising some of the US companies?
Thank you, Nishchal. Thank you, Nishith Desai Associates for having me on this session, and I really appreciate that. I think as just to little background for all our attendees, Brand Capital International is a strategic investment arm of the Times of India Group, or Bennett Coleman and Company in India. Yes, I have worked in the past with international companies like Yahoo and Microsoft, was more on the business side of it. In the last 6 years, one of the things that we have been doing in the international market is really, being the flag bearer of India, if I may say so. We actually go across to many leading consumer tech companies and talk to them about the importance of India. We also have a website which is India 101 called thinkindia.io, which I recommend attendees to visit as and when they want it, those especially from overseas. But the most important thing is that as a flag bearer, we actually talk about the importance of India in the global market. India is, as most people know, is one of the largest consumer economies in the world, and which is why most companies outside India actually looking at how to work with India and within India. And of course, we have invested in some leading companies like Uber, Coursera, Airbnb, and then early stage companies like Square Panda, OddUp, etc., totaling over 25 investments. From overseas to most of these companies, there are a couple of challenges which they constantly face. The first thing is that from outside India, sitting in their own countries, India comes across as extremely opaque, with a lot of challenges, not knowing what to do where, what's the regulatory approach to go about. I think that's one of the gaps that Brand Capital International tries to actually bridge, is how do you not only just look at the regulatory and compliance part of it as to how you can land your company in India, but we also talk about how do you reach out to your customers. And that is where the power of the media really comes into play, where we have reach across our various media platforms and how they can connect to their consumers, which are across multiple states in the country. The pandemic has definitely changed things. Obviously, the fact that it's all now digital first creates its own set of challenges. And one of the challenges for consumer tech companies, apart from the regulatory and compliance part of it, is this whole issue about data privacy in India. How do they manage this little monster which is there? And I'm aware that India does have a paper on that, but even though there are efforts to really make things go digital, the data privacy law has still really not been passed. So all the large companies which are using the online medium have a challenge how to address some of these challenges. So there are questions around that. So yes, like Harshita mentioned, there are different ways in which you can build your structures currently. One of the simplest things that most international companies look at when they consider India is how do we find a simpler way to enter India without going beyond the red lines which have been drawn across the board. And that's the challenge that we face when we engage with these counterparts out here. And the easiest answer really is to restrict investment to see how it goes. And what I'm trying to bring about here is that the constraints that some of them have, both regulatory and legal, as well as, like I said, data, they tread very, very slowly, which slows down the level of participation within a growing consumer market like India. I believe that there are a lot of efforts which are being done on the Indian side, but I would definitely believe that an acceleration of that would certainly open up the doors much faster for some of the companies. So these are challenges which are ongoing. I think the most important thing is how do you handle the power of the internet, and how do you deliver products and services from another geography into the Indian market, and what are the rules and regulations around that are going to be critical as we go forward.
Great. Thanks, Neville. Thanks, Neville. Yeah. So I think I'll talk a bit about one of the interesting structures that we have been working on since the last few months. This is what we call the SPAC structure. SPAC is basically a special purpose acquisition company, and SPACs have become a buzzword in India since the time Renew Power, which is the largest renewable power company in India, announced its plans to get listed on NASDAQ through the SPAC structure. So why have SPACs become important for Indian businesses? I wanted to touch upon that a bit. In fact, as we are speaking, we are working on 3 to 4 SPAC listings for some of the Indian companies and who have looked at Indian markets but have not been very happy with the way the Indian investors and the Indian markets have been offering the valuations. So some of the reasons why a lot of Indian companies are now looking at listing on NASDAQ or NYSE through SPAC structures are as follows. The first one is, there are 3 options typically available with any Indian company. One is a direct listing on Indian markets. The challenge with this has been for some of the new age companies, especially some of the unicorns in India. The Indian markets are not offering as great valuations as you would get it on NASDAQ or NYSE. And that's one major reason why some of these unicorns are looking at overseas listing. The second reason is the flexibility you get in offshore jurisdictions on the capital structure is completely different from the flexibility that you get as an Indian company, because as an Indian company, there are restrictions on how much you can issue in terms of different class of shares with differential voting rights, differential economic rights. And it becomes challenging as per the Indian securities laws to issue some of these kinds of securities without any restrictions. And this is where we have seen when you are able to externalize the Indian company to an offshore jurisdiction and list that offshore company on NASDAQ or NYSE. It is there's a lot of flexibility in the cap structure that is provided by these offshore jurisdictions. So that's another major advantage. But as I mentioned, some of these new age companies and the unicorns have not been very happy with the valuations offered by the Indian investors. And that also one of the reason has been the sophistication in understanding some of the new age businesses which US investors have is not there with the Indian investors. The second avenue is to use the ADR GDR route, which was introduced in 1993 in India. But at that time, the issue was that ADR GDRs can be issued only with underlying securities as listed securities of Indian company. So anyways, the Indian company had to first list in India and then only it can issue ADRs GDRs. So it was not very helpful for unlisted companies in India who didn't want to access Indian capital markets and directly go to US markets. In 2014, this 1993 ADR GDR scheme was repealed almost after 21 years. And there were certain interesting amendments that were introduced where even unlisted securities could be issued as an underlying for ADR GDRs. And that was a huge shot in the arm for some of the unlisted companies and the unicorns where they thought that they'll be able to access international markets without listing in India. But unfortunately, as we know, the regulators in India did not coordinate well, and there were no changes that were introduced under exchange control regulations by Reserve Bank of India or in the tax laws by the tax department. And this is where the changes that were introduced in 2014 could not really materialize into great capital markets for India. Interestingly, in 2019, SEBI came up with a circular which again stated the same position that you can only have underlying securities as listed securities. So back to square one, where we were in 1993, in 2019. The third structure that a lot of Indian companies are now excited about is the announcement which the government made in March 2020, which is to allow the shares of the Indian company getting directly listed on foreign exchanges. So this time you don't have to list your ADRs, GDRs. You can directly list the shares of Indian company on NASDAQ or NYSE. And this, if it becomes operational, would be a significant booster for some of the Indian companies. Having said that, the challenge has been that, again, we are 14 months since this announcement was made in March 2020, and we haven't seen any amendments in the tax laws or in the exchange control laws or in securities laws, which will make this amendment effective for the Indian companies. So on account of these three structures not being very feasible at this moment for some of the unicorns or some of the worthy unlisted companies, we have started seeing a lot of interest in some of these companies for SPAC listings. And there are many advantages to SPAC listings compared to a traditional IPO. Like one I mentioned is the cap structure is more flexible in an international jurisdiction as compared to in India. The second advantage is in a traditional IPO, there are restrictions on giving financial projections. And you typically have to rely more on the historic results of the Indian company. Whereas in case of a SPAC listing, subject to certain safe harbor rules of SEC, it is possible to give financial projections. And that works quite well for some of the new age companies who are more futuristic as compared to showing their historic performance. I think the third major advantage of a SPAC listing versus a traditional IPO is in SPAC listing, typically it ends up being a bilateral determination of the valuation because the founder of the SPAC and the promoters of Indian company will typically negotiate the valuation, which in turn will become the IPO valuation. Versus in a traditional IPO where valuation is dependent a lot on many factors, ranging from how the economy is working, the book building process, the merchant bankers, what's their view on the valuation. So a lot of things that come into play in a traditional IPO compared to a SPAC listing. And I think the fourth important thing, obviously, if at all the Indian companies are looking at SPAC listing, what becomes important is to also look at the investors in the SPAC, because typically a lot of fixed income arbitrage investors, they typically invest in the SPAC. And it becomes important that when the SPAC acquires the acquisition target, they have the flexibility to immediately transfer their shares in the market, which in turn can result in a huge pressure on the stock price. So for the promoters of Indian company, it becomes important to understand that the SPAC has long-term investors rather than short-term fixed income arbitrages to ensure that the stock doesn't get pounded immediately after listing of the target. So I think broadly, as I mentioned, SPAC is becoming the flavor of the season for a lot of Indian companies. And it's one very interesting avenue which we are all looking at. The government of India has also introduced SPAC regime under GIFT City, which is the International Financial Center of India. It's still work in progress, and there are a lot of other laws that need to flow in tandem to make that effective. But that's also something which we are waiting and watching to see if that materializes, and that will be one more avenue for Indian companies to list. So I think with this, I would request Ratnadeep. I think we have spoken about the various structures for foreign investments into India and for Indian companies to go global, and even the innovative structure, which is a SPAC structure that's coming up. But there are a lot of regulatory issues that any foreign investor has to face when they invest into India. Can you share your thoughts on that, please?
Thank you, Nishchal. Again, firstly, thanks for being part of such a fantastic panel and this very invigorating discussion that I think gives a great introduction into the rest of the topics of the seminar, because in the new age industry as well as the traditional industries, many of the rules relating to foreign investment and the rules and regulations that people need to be mindful of are common. So as Harshita has already described, a large part of the structures that are often employed by foreign investors when investing into India, and you've of course expounded on SPACs. What I thought I would try and cover in the next few minutes is maybe three broad topics or three broad areas of laws that any investor needs to be mindful of, or at least look at initially while deciding how and what to invest in India. So the first one, of course, is in terms of foreign exchange regulations, part of which Harshit has already dealt with. I'll also speak about certain aspects of the Companies Act that become relevant, and then also speak about antitrust and competition law issues. So on foreign exchange regulations, I think the first thing to sort of the first thing that jumps out is to always remember that we India are not a completely capital convertible account country. What that means is that any transaction that is on the capital account, so be it buying and selling of shares, be it the financing and the provision of loans, be it the creation of any encumbrances, or even the buying and selling of physical assets, specifically movable property, all of these are considered to be capital account transactions, and therefore they are regulated. The act in question here would be the Foreign Exchange Management Act, which is which also has various rules and regulations under it, which detail out the specific rules. So all of these are capital account transactions, and therefore they are governed and regulated by the Foreign Exchange Management Act, and that act is implemented by the Reserve Bank of India as the principal regulator. Now, in terms of our foreign exchange regulations, both inbound investments as well as outbound investments, as well as remittances from realizations of investments from dividends, all of these are sort of regulated by the Foreign Exchange Act. There are specific guidelines dealing with each of them. Another thing from the foreign exchange angle that would be important to always bear in mind is that RBI and the framework of the Act very clearly distinguishes between debt and equity, and is sort of confused in terms of how to deal with quasi-equity, which consists of various convertible instruments which are quite popular and sort of well understood in many jurisdictions. The regulations around debt are very distinct from equity, and the approach of the regulations is clearly that someone taking an equity risk needs to bear the downside risk of any erosion of value of that equity, and therefore they can't camouflage it in the form of debt and enter the country through that route. So that's something very an important point to bear in mind. The other important point to bear in mind when investing into India from a foreign exchange perspective is the issue of pricing guidelines. So the baseline understanding that one needs to sort of absorb is that whenever there is a non-resident buying an Indian asset, the underlying principle is that he must at least pay the fair value. And similarly, when a non-resident is realizing the value of an Indian asset, he cannot realize more than the fair value. So that's sort of the baseline understanding. Now we have, I think, traveled a great direction in terms of providing flexibility to international investors in determining what that fair value is. But this underlying requirements still continues. Apart from valuation, again, from a foreign exchange angle, when structuring investments, you would also want to consider what are the kind of instruments that one can invest in. And even there are permissions provided for a variety of instruments such as shares, warrants, convertible debentures, convertible preference shares, and similar instruments. But again, each of them come with their own specific subset of sort of rules and regulations. I think we are sort of a little short on time, Nishchal. So I think I should move quickly on to antitrust and
I think
acquisition.
Ratnadeep, we don't have any questions, so I think we can.
We have some time. Okay, great.
Yeah, we have.
So again, in terms of foreign exchange regulations, as I mentioned, one important aspect is to understand the kind of instruments that one can invest through and what are the rules and regulations applicable to those instruments. Again, an overarching comment here would be that we are progressively liberalizing. I think that is the direction of travel clearly in India. And over the last many years, we've seen more and more instruments being allowed, more and more flexibility being allowed. But one needs to be careful and take advice in terms of what are the instruments and what are the rules when structuring or thinking about one's investment. There are other typical aspects which you would see in deals elsewhere, as Eric mentioned, in terms of deferred consideration, in terms of escrows, in terms of what you can provide by way of indemnity. Even those are specifically allowed under foreign exchange regulations, but again, with rules. So while most, I think the overarching statement would be, while most things are allowed, there are certain rules and regulations almost on everything that one needs to bear in mind and take advice on. A couple of other things that one should be alive to when considering foreign exchange regulations is the rules that it has in relation to outbound investments out of India. And what often happens is if an entity has invested outside India, that target entity sometimes may have some operations or may have some assets in the Indian jurisdiction as well. Now, that is not considered favorably under the foreign exchange regulation and is often discussed as round tripping. Again, there are ways and means to address that issue and structures that do work even within that framework. But again, something that ideally one should take advice on and be careful about. So this is again a broad perspective of the various intricacies of the foreign exchange regulations and which sort of apply at every step in an investment into India and which people have to bear in mind. The other thing, the second sort of topic I thought we could speak about a little bit would be one which is often given a pass, which is the Basic Companies Act, which again is investments today. Okay, so to take a step back, foreign investments into India are permitted in a variety of vehicles. So you could invest in a limited partnership, you could invest in units of trusts, you could invest in a single member company, but by far overwhelmingly the most popular mode of investment vehicle would be an Indian registered company. So what is therefore directly relevant would be the rules and regulations that govern the basic corporate structure in our country. And again, to give a sort of a broad overview, it's based on the UK Companies Act. It's broadly similar to what you would see in companies elsewhere, where you have a board of directors who perform the executive functions, but who also have a body of shareholders who have the final say on all matters. Now, very specifically in terms of investments and the M&A and deal structures that would draw from the Companies Act, it's helpful to note that the jurisprudence in India has developed to recognize most of the usual features in a shareholders agreement or in a purchase agreement that you would expect to see worldwide, including veto items, including pooling arrangements, including upon nominee directors and such like. A broad rule of thumb is there are two types of companies in India, private companies and public companies, and it's always easier to implement inter se arrangements through a private company, which, as the name suggests, is intended for a smaller group of shareholders. Another, aspect of the development of the corporate jurisprudence that sort of shows the kind of communication between different regulators that Nishchal spoke about earlier is, the notification and the implementation of some the significant beneficial ownership rules under the Companies Act that took place a short while back. Now, again, something that foreign investors into India should, I think, also bear in mind in terms of how those rules operate and what could be the repercussions of it. They are essentially intended to find out the ultimate beneficial owner passing through various corporate veils and to determine who would be the final sort of beneficiary that authorities in India could reach out to in certain circumstances. Obviously, there are many implications that one needs to think through of declarations of this nature, be it from a taxation angle, be it from, as I said, the round tripping angle. But this again is the kind of the sort of approach that Indian regulators are today taking, and shows the sort of savviness that Indian regulators have now developed to sort of look beyond the general corporate structures that are put in place in an investment and to try to get to whichever individual or party is at the root of it all. The third aspect that, Nishchal, I thought we could speak briefly on would be the antitrust and competition law is relatively recent, although it's now been well over a decade that it's been in operation. I know that there is a subsequent session which will deal with it in greater detail, but I'll try and give a broad overview in terms of where it's relevant for M&A and investments. Competition law deals, the Act deals both with behavioral aspects of antitrust law as well as aspects dealing with combinations. So you have provisions that deal with anti-competitive agreements and acts, provisions dealing with abuse of dominance, but also provisions dealing with combinations. Now, the important thing again here to remember about the Competition Act, special feature, unlike many other Indian legislations, is its express extraterritoriality. So if there is a global transaction that is happening, but which has an Indian component, there needs to be an analysis done to see whether Competition Act provisions are attracted even for that transaction. And the reason it needs to be done is because the format or the structure of the Competition Act is that it obligates parties to a combination to suspend the operation of the combination till such time as the Commission has cleared that combination. So that's one important reason to ensure that one doesn't trip up on these provisions. More generally speaking, the way combinations are governed in under the Act is that it addresses almost all forms of acquisition of shares, voting rights, control, as well as assets. There are, of course, significant thresholds that are available to make sure that every M&A and private equity or other acquisition transactions are not caught up with it. But there are a fair number of transactions that we have seen require notification. Even notification has sort of two levels. If there is a significant level of horizontal or vertical overlap, then one would need to engage in a very comprehensive and extensive exercise of convincing the Commission. But in the majority of the cases, what we've seen is that a simple filing is made where basic details are provided. And under the framework of the Act, the Commission is obliged to clear a transaction between 30 and 210 days. So if it does not respond, the transaction is considered to have been approved. So again, this is sort of the basic Indian leg, obviously check on Competition Act. There are aspects of gun jumping, which means, as I said, the structure of the Act is such that you can't give effect to a combination before it's cleared. So we have to be careful when we sign term sheets or we sign binding engagements or any other documents which have a binding effect in terms of a transaction to evaluate whether or not the Competition Act would permit the same. The other aspect in terms of, wrap it up. The other aspect I would highlight is having control over the kind of press releases and the kind of communications we make in public. Again, going back to Nishith's point on how savvy the regulators are, we have seen the Competition Commission picking up on these public statements to pursue their investigation. So I think I'll conclude there, Nishith.
I know that was quite comprehensive. Thanks, Ratnadeep. Just to add one more point, which is very important for the participants to know, is that in the last decade, India has moved from a form over substance to substance over form regime as far as structures are concerned. So 10, 15, 20 years back, the regulators would typically look more, at the letter of law and see whether, things have been, structured as per the letter of law. But if you see the last decade, where both in the tax law and in the regulatory regime, a lot of substance related requirements have been introduced. So for example, under tax laws, we have general anti-avoidance rules, which means the tax department will see more of substance in the transaction more than the form. And even from a regulatory perspective, we have seen the enforcement directorate becoming quite active in various cases where they see that, the substance form has been satisfied, but not the substance. So as lawyers, it becomes very important for us to ensure that we don't just, clear structures based on what's written in the acts, but also apply our smell test to see that if tomorrow, let's say tomorrow morning, if the structure is in the front page of Economic Times or Business Standard, we don't panic and we are able to easily justify why we did certain things. And which is where what becomes important is how you document various agreements, how you document various internal notes, how you draft the board minutes, how you draft the investment committee meeting minutes, because all the justifications for taking a decision should be properly documented, because these are the things that will help you in case there is an investigation that takes place in future from any of the regulatory authority or from the tax department. So I think that was something that I thought it's important for the participants to know. But let me just request if Eric or Neville or Harshita, if you have any concluding comments for the session, it would be great to hear from you. Eric, if you have anything to add.
Yeah, first of all, thank you so much for having me. I appreciate it greatly. I guess the one thing I'd say is, on the heels of what you've all said, and maybe some of it's a little obvious, is that as you think about expanding M&A activity, particularly into new markets, I think having, I'll call it a local presence there, people on the ground who you trust, who you work with closely, and to provide you with the proper advice to help you execute efficiently, appropriately, and accordingly is really key. The other thing I'll say is really briefly, and that I've learned over the years, is some of the best deals that I've done are the ones that I've actually, I'll say, walked away from. So, watchwords are: don't fall too much in love with your targets. Stay clinical, stay logical, stay rational, and thank you very much for having me.
You have any final comments?
None from my side. Thank you, Mir.
Yeah, so thank you very much for having me. I think I allude to a lot of stuff that Eric has said. One needs to be mindful and of what and how we, sort of advise and structure deals. One of the key things what Ratnadeep said is to keep a record of how those investment committee meetings are organized and decisions taken. And I think those are very key aspects of how we need to handle investments into India. And I think over time, once one does that, you become better and better at doing it. I think I saw one of the questions by a good old friend of mine in the question box said, what is the URL? Unfortunately, I'm not able to type that URL of Think India. It's basically for the benefit of whoever's on the call. The website address is www.thinkindia.io. I'm not able to respond in the chat box for some reason, but anybody interested in looking at the website, which we market internationally, it's thinkindia.io. So that's it from my side. Mir.
Thank you, Neville. Thank you, Nishal, Eric, Harshita, Ratnadeep. Very
So,
enlightening session.
Mir, I think we have 2 minutes left, and I just wanted to take one question,
Sure.
if it's okay.
Nishal, actually, I would like Nishith to give the closing remarks, so maybe a couple of minutes on
Sure,
that.
that's
And
fine.
then
That's fine.
this is absolutely important that participant questions we answer. Just 1 second, Nishith.
Very interesting discussion. I think you
Nishith,
can.
just 1 second. Hold on a second.
Okay.
We have Nishal. We have the breakout session.
We'll do
After
that.
this, where absolutely you can take up. But Nishith, sorry about that. Any closing remarks before I make the final closing announcements?
Wonderful. I think it's so much insight into this particular session, and I always believe, we talk about structures and other kind of stuff, and I think it always precedes by what's called strategy. So structure follows strategy. In architectural language, we call form follows function. And therefore, it's very important to have a broad strategic approach in mind. And then you can decide what kind of structures will evolve, investment structures, for the acquisition, FDI, direct investment, indirect investment, and all this kind of thing. And but all the finer aspects that were discussed this evening, been amazing. There's a maze of things around, but walking through that itself is kind of a challenge, and at the same time excitement. I think so one good thing about India is that we have some kind of rule of law. Of course, many a times, it's a bit of a problem, but there's some method in madness. So, when you develop structures, ultimately, if it is legally compliant and tax efficient, I think by and large, they do work. Well, although there is litigation issue, which all of us know, and those ones are how to avoid those risks. I think great job done, by Eric and Ratnadeep, Darshita, Nishchal, and all of you. So my compliments to you for this evening's discourse, and I appreciate it. Thank you so much. Please.
Wonderful, Nishith Desai. Just closing comments, couple of comments. First of all, we have applied for special CLE credit, MCLE credit with the State Bar of California and New York. So if you would like to receive the credit from the State Bar of California and New York, please write to lynette.h@nishithdesai.com, and you must mention this code 94404 in order for Lynette to take it forward and apply the credit for you. Now, with that, we are basically closing this session and moving to tomorrow's item I would mention. Tomorrow we have two sessions. First one on regulatory considerations in various business models, which is supported by IAMAI, which is the Internet and Mobile Association of India. And the second session is about data ownership and protection. Digital economy is all about data, but data comes with its own issues related to privacy and security and data protection and all of those. So we have panel of experts, 5 experts joining us tomorrow in the second half, in the second session, which is supported by Fiki. So thank you again for joining today at Digital June, and we look forward to having you again tomorrow. Meanwhile, after this session is over, you can go to individual speakers breakout session, just like meeting speaker on the sideline after the talk. So thank you for joining, and I request speakers to go to their breakout session. Thank you.